Court of Scarborough Circuit Court is now in order. The Honorable Supreme Court Justice Pamela Goodwine presiding. I greased it down. Please be seated and come to order.
Good afternoon, everybody. We are here this afternoon for the trial in the matter of Robin McLean versus Thunderbolt Security, Inc. My name is Justice Pamela Goodwine. I would like to remind competitors, including timekeepers, that you may not use cell phones for any reason. You may not communicate with anyone other than your competing teammates during the round. Spectators, please remember, this includes you. Students may not communicate with you until the round is over and ballots have been accepted by the tab room. I would also ask that everyone make sure that their cell phones and electronic devices are off or on silent. And if you need to leave the courtroom, please make sure to do so quietly and, if possible, at the end of a witness's testimony or other break in the trial. Counsel, are there any matters that we need to take up before we have opening statements?
Yes, Your Honor. First, may we make introductions to the court?
You may.
Good afternoon, Your Honor. My name is Caitlin Folks. I will be conducting the direct examination of Corey Spencer and the cross-examination of Riley Gallatin. I'm joined by my co-counsel.
Good afternoon, Your Honor. My name is Kellen Harper. I'll be conducting the direct examination of Sean Owsley, the cross-examination of Max Casey, and I'll also be presenting the opening statements for the plaintiff today.
Excellent.
Good afternoon, Your Honor. My name is Mallory Jones, and I'll be conducting the direct examination of Robin McLean, the cross-examination of Lane Elliott, as well as delivering our closing arguments.
May our witnesses make introductions?
Absolutely.
Good afternoon, Your Honor. My name is Joshua Hughes, and I'll be portraying the role of Robin McLean.
Good afternoon, Your Honor.
Good afternoon.
My name is Ella Houghton, and I will be portraying Sean Owsley.
Good afternoon, Your Honor. My name is Carter Johnston, and I will be portraying the role of Corey Spencer.
Excellent.
Would you prefer that we move on with further pre-trial matters, or would you like the defense to make introductions first?
I would like the defense to make their introductions.
Yes, thank you, Your Honor. My name is Will Blake for the defense. I'll be conducting the direct examination of the defendant, Lane Elliott, as well as the cross-examination of Professor Corey Spencer.
Good afternoon, Your Honor. My name is Aaliyah Bradshaw. I will be giving the direct examination of Riley Gallatin, the cross-examination of Sean Owsley, as well as delivering the defense's closing remarks.
Good afternoon, Your Honor. My name is Henry Spraggins. I will be conducting the opening statements. I will be direct examining Max Casey and cross-examining the plaintiff, Robin McLean.
And our witnesses in the order they'll be called.
Good afternoon, Your Honor. My name is Savannah Campbell, and I'll be portraying Lane Elliott.
Good afternoon, Your Honor. My name is Jackson Hibbard, and today I'll be portraying Max Casey.
And good afternoon, Your Honor. My name is Michaela Doherty. I will be portraying the role of Riley Gallatin.
Thank you for those introductions. Counsel, you may proceed with other pretrial matters.
Yes, Your Honor. First, may we move freely about the well?
You may.
We would like to call the court's attention to Special Instruction 8A2, which states that the information contained in Max Casey and Corey Spencer's affidavit is sufficient enough for their testimony to be presented to the jury as long as both parties lay the foundation.
Okay.
We would also like to call the court's attention to Stipulation 10, which states that Exhibits 1, 7, 8, and 9, and 10 are admissible in their current form as long as the witness has knowledge of the document.
Okay.
We would also like to call the court's attention to Mock Trial Rule of Competition 3C, which states that witnesses are bound by the statements in their affidavit. Your Honor, we would like to ask at this point if all witnesses are assumed to be sworn in, or if you would like to do that individually.
The witnesses are assumed to have been sworn in.
Thank you, Your Honor. With that, the plaintiff is ready to proceed.
You may call your first witness. Or no, opening statements.
Oh, Your Honor, if the defense may, we have a couple preliminary
You have a couple
matters
preliminary
as well.
matters? Thank you.
Just a few, we'll keep it brief. The defense requests to have the defendant, Lane Elliott, sit among counsel. And likewise, we would like to call the court's attention to Special Instruction 8, Section A, subsection 1, which states that yes, Corey Spencer may testify about the indicia of discrimination, but may not declare whether or not Thunderbolt Security did or did not discriminate definitively.
Correct.
With that, the defense is ready to proceed.
Thank you, counsel. We will now hear opening statements, beginning with the plaintiff.
Yes, Your Honor. May I proceed?
You may.
Your Honor, opposing counsel, members of the jury. Thunderbolt's actions speak to a pattern. Thunderbolt Security time and time again used age as a basis for getting rid of and firing employees. My client, Robin McLean, was a victim of these discriminatory actions. We are here today because Robin McLean was not only fired, but completely looked over for a job opportunity. Not because Robin was unqualified, not because someone better applied, and not because Robin was incapable of doing the work, but because Robin is 63. Their actions speak to a pattern. Now, in most civil cases, the burden lies with the plaintiff, meaning it is up to us to prove our charges by preponderance of the evidence, meaning more likely than not. However, this case is slightly different. We have what is known as a shifting burden, and the burden starts with us. We will show you that Robin was more than qualified for the position with over 40 years of experience on the job under his belt. After this, the burden will then shift to the defense, who must show a legitimate, non-discriminatory reason for the hiring decision of the non-protected person over Robin McLean. The defense will give you a reason, but it will be far from legitimate. Robin McLean was the most qualified candidate for the position, and we will make that abundantly clear. Now, let's say that hypothetically the defense is able to give a believable reason. The burden then shifts back to us to show that a non-discriminatory reason for the hiring decision was in fact pretext for discrimination, an excuse not to hire my client, a lie used to cover the real reason. We welcome this burden. We welcome the opportunity to show that Thunderbolt discriminated against my client, and we will show you that Thunderbolt's actions speak to a pattern. Now, Lane Elliott is the owner of Thunderbolt Security. You will learn that as soon as Lane took over the company, they wanted it to be younger. She will try to disguise this fact by saying she wanted tech-savvy employees, but don't be fooled. Their actions speak to a pattern. Today you will hear from Sean Owsley. Sean will tell you that the first decision Lane made when taking over the company was skipping over Sean for the position of HR director. You should find it interesting that Sean, 52 years old, worked at Thunderbolt for 25 years and was assistant HR director. You should also find it interesting that instead, Lane decided to hire a younger friend from college who had nowhere near the experience Owsley did. Their actions speak to a pattern. Today you will also hear about a round of layoffs Thunderbolt called a right-sizing. I ask that you pay attention to the ages of those that were fired. The comparison is astonishing. Their actions speak to a pattern. Next, you'll hear from Corey Spencer, who teaches and specializes in ageism and discrimination. Corey will tell you about an ad Thunderbolt used when making the hiring decision that brought us here today. I ask that you pay attention to the words, phrases, even pictures used by Thunderbolt. They knew the type of employee they wanted to hire. Unfortunately, my client was just too old. I also ask that you pay attention to the effects the ad had on the individuals that applied and the ages of those that were actually hired. Their actions speak to a pattern. Lastly, I ask that you pay attention to the hiring decision of Robin McLean, the far superior candidate with decades of experience. Throughout today's trial, you learn that Lane views Robin as an old-timer. And in Thunderbolt's eyes, that meant it was time to go. Their actions speak to a pattern. Lane's vision speaks to a pattern of age discrimination. Through their actions, Thunderbolt has shown time and time again that age does, in fact, matter. That younger is better. And that they do not want anyone who does not forgive you, regardless of their qualifications. Robin McLean was the most qualified candidate for the position and did not receive the job simply because of their age. The textbook definition of age discrimination. And at the end of today's trial, my co-counsel Mallory Jones will come before you and ask that you find Thunderbolt Security liable. Thank you.
Thank you, counsel. We will now hear the defense's opening statement.
Yes, Your Honor. Am I free to proceed?
You are free.
Thank you, Your Honor.
Thank you.
May it please the court, opposing counsel. Good afternoon, ladies and gentlemen of the jury. My name is Henry Pierce Spraggins, and I, alongside my co-counsel, Aaliyah Renee Bradshaw and John William Blake, have the honor of representing the defendant, Thunderbolt Security, and its current owner, Lane Elliott, in today's case. Now, you just heard the plaintiff's theory that their client, the plaintiff, Rob McClain, was discriminated against, when my client, the defendant, Thunderbolt Security, chose to not hire him for a position. I'm here to tell you, of course, that that's not what happened. They left out one crucial detail in their opening statement. If we, as the defense, prove even one legitimate, non-biased, non-discriminatory reason for not hiring Rob McClain, there's no case for ageism. We're here to tell you that that's what happened. Rob McClain not only was not qualified for the job, he was not the most qualified candidate altogether and posed a liability risk to Thunderbolt had he been hired. You're going to hear a lot about Rob McClain in today's case. Robin did work for Thunderbolt for almost 41 years. Robin saw the company go through the pandemic. The pandemic was very malignant to Thunderbolt Security. The entire industry changed during the pandemic as there was no demand for physical security guards. In its place, cybersecurity took hold. The entire industry changed. Thankfully, Thunderbolt did survive the pandemic under the leadership of its current owner, Lane Elliott. This was mostly due to the right sizing conducted by Lane, where they had to unfortunately lay off most of their guards to survive. Now, as they did improve after the pandemic and margins returned to healthy ones, they were able to hire on new guards. But note this change of the pandemic. They were looking for a new type of guard. The new guard that Thunderbolt was looking for had to be tech-savvy and adaptable to security technology systems. That candidate was not Rob McClain. Now, after Rob McClain was unfortunately let go in this layoff, he decided to take a handful of classes at a local community college in cybersecurity. After doing this, he reapplied for a position at Thunderbolt, assuming that his limited education and antiquated experience would guarantee him the position. But again, ladies and gentlemen, he was not the candidate for the job. In his place, Ashley Owen was hired. Ashley is a strong young woman. She will move up in the ranks at Thunderbolt with ease. She is intelligent. She has a full degree in security with an emphasis in cybersecurity. Quite frankly, she is very passionate about security, and she is exactly the candidate that Thunderbolt is looking for. Rob McClain, on the other hand, was not. Rob McClain, in his time at Thunderbolt, had a myriad of disciplinary actions on his track record, one of which he deleted crucial footage from a client's venue that almost got them in serious legal trouble. He made stupid mistakes like leaving key cards out and staying logged into security systems. He posed a liability risk to Thunderbolt Security. He may have been good in the older days, 40 years ago, but the current Thunderbolt is not looking for this kind of guard. You're going to hear from 3 witnesses from our side in today's case. Professor Max Casey is the current operator of the Security Studies program at Scarborough Community College, where Mr. McClain took classes. Mr. Casey will testify today that Robin was an okay student, took a handful of classes, and didn't seem to improve much. Ashley Owen, on the other hand, he will testify, was a great student and a perfect candidate for a modern-day security job. You will also hear from the current owner of Thunderbolt, Lane Elliott, and the current head of HR, Riley Gallatin. They will both explain comments taken to be ageist by the plaintiff's witnesses, and they will also testify that the original layoffs were crucial to the survival of the company. Ladies and gentlemen, at the end of today's case, you will be asked to decide whether or not my client, Thunderbolt Security, was discriminatory in their decision not to hire the plaintiff for this position. We're here to tell you that that's not what happened. There are plenty of legitimate, non-age-based reasons for not hiring Mr. McClain. And with that, we ask that you, based on the preponderance of the evidence, find my client not liable to Mr. McClain. Thank you.
Thank you, counsel. Plaintiff, ready to call your first witness?
Yes, Your Honor. At this time, we call Robin McClain to the stand.
Mr. McClain, you may come up, take the stand, please. You've been placed under oath. You may proceed.
Please introduce yourself to the members of the jury.
My name is Robin McClain.
What do you do for a living?
Currently, I do not work, but for over 40 years, I worked as a security guard for Thunderbolt Security. I started way back in 1980 and I worked up until 2021.
Why do you no longer work for Thunderbolt?
I was let go during COVID. The company had a round of layoffs, you know, with less events happening, the need for security guards just fell off.
What did you do once you were laid off?
Well, not that being laid off is a good thing by any means, but chances are I was going to have to leave my job anyway. My wife had just been diagnosed with cancer, and I was going to stay home and take care of her.
And did you have any other work during this time?
No, I cared for my wife, but I did decide to go back to Scarborough Community College and take some classes down there.
Why did you want to take these classes?
I recognized that technology was one of my weaker areas. They offer classes in physical and cybersecurity. I wanted to get better. I wanted to challenge myself and improve. I couldn't go full-time, but I did decide to go part-time.
Now, when you say technology was one of your weaker areas, what do you mean by that?
Well, like I said, I worked at Thunderbolt for over 40 years, and of course the technology changes. When I first started, I was always able to keep up, but the turn of the century just made it a little bit harder on people like me who grew up with Walkmans and VCRs, you know, without all this technology. I actually ended up having trouble with one specific operating system while I was working.
What system is this?
It was called Artemis. It was a notoriously finicky system, and I didn't think that it was very user-friendly. It managed the security systems, and it stored footage.
What trouble did you have with the system?
I accidentally deleted some footage while I was trying to copy it over. It was a common error for this system, but it just so happened that this footage held information that was important to the club we were working at. A patron had been injured, and this footage would have shown that the club was not at fault.
How did all of this get resolved?
Thunderbolt Security paid to have the footage recovered. It was my mistake, and I took responsibility for it. But, you know, that system is so pitful, they don't even use it no more.
Now, Mr. McLean, did you get in trouble for this?
I did. They issued me the last chance employment agreement.
Your Honor, at this time, I'll be referring to what was previously marked as Exhibit 3. Let the record reflect I'm showing a copy to opposing counsel.
Record so reflect.
And would the court like a courtesy copy?
Please.
May I approach?
You may.
And may I approach my witness?
You may. Thank you.
Thank you.
For Mr. McLean, what is this document?
This is the last chance employment agreement that was issued to me by Thunderbolt Security.
Is it a fair and accurate copy?
It appears to be.
Your Honor, at this time, remove this document into evidence as Plaintiff Exhibit 3.
No objection, Your Honor.
Plaintiff's Exhibit 3 is admitted in evidence.
Now, Mr. McLean, what did this entail?
Basically, it said that this had been a fireable offense and that I was to review the Artemis system and that I was on probation, as a way to say it, for the next year. It felt a little bit harsh to me, like I was some kind of scapegoat for this terrible system.
Your Honor, at this time, I'll be referring to what was previously marked as Exhibit 1. Let the record reflect I'm showing opposing counsel a copy.
So reflect.
And would the court like a courtesy copy?
Please.
May I approach? And may I approach my witness?
You may.
Now, Mr. McLean, what is this document?
This is the ad that was posted by Thunderbolt for the job that I applied for.
And is it a fair and accurate copy?
Yes, it is.
Your Honor, at this time, remove this into evidence as Plaintiff Exhibit 1.
No objection, Your Honor.
Plaintiff's 1 is admitted.
And may we publish Exhibits 3 and 1 to the jury?
You may.
Now, what type of work was this job posting for?
This was for an entry-level security position. Not cybersecurity, but the frontline guards like I had been.
Now, I see that it lists several jobs that you might be responsible for. During your 40 years of working for Thunderbolt, did you ever do any of these jobs?
Yes, all of them. We already talked about my security system mishap, but like I said, I've been addressing that. And all this other stuff I never had any problem with. This job was kindly perfect for me.
Now, Mr. McLean, did you need a college degree to apply for the job?
No, you just needed a high school diploma, but some technical or college training was preferred. But like I said, I took classes down at the community college.
Right, so what types of classes did you take at the community college?
Well, I took classes that would expose me to newer technologies, you know, your computer softwares and hardwares and new internet systems.
Now, one of the qualifications is ability to stand or walk patrols. Did you have any issues with that?
Never. I may not be as young as I once was, but I'm as in shape as I ever was. I'd like to see anybody, someone even in their 20s, try and keep up with me.
Another one of the qualifications is ability to adapt to different technologies. Can you do that?
Yes, I worked in this industry for 40 years, and I went to school specifically to learn about new technology systems. Yes, I can adapt.
Now, Mr. McLean, did you have to interview for this position?
I did. I went in for my interview on January 4th of 2023.
And did you happen to know the person giving you the interview?
I did. It was Riley Gallatin, the person who had originally laid me off.
Now, what all did Riley ask you about?
Well, first, Riley went over the job description and the duties, of course, and then asked me if I agreed that technology was one of my weaker areas. But like I said, I've been addressing that.
And did she ask you anything else?
Yes. Riley asked me if I thought that if I would be able to adapt, and Riley also asked me if I thought I'd be able to keep up. I was never, ever one to slack. I didn't care about new bosses or new systems. I just wanted to get back in the game.
Now, Mr. McLean, were you hired for the position?
I was not.
So why did you decide to file this suit?
Listen, I understand that I'm a little bit older, but I've got some good years left in me. I know that I can still do this job. I've been growing and adapting in this industry for over 40 years, and they don't pick me because I've been around the sun a couple more times than somebody else. I should have been given this job.
Thank you, Your Honor. No further questions.
Class Finley?
Yes, Your Honor, may I proceed?
Yes, sir.
Thank you. Now, Mr. McLean, you were originally hired at Thunderbolt in 1980, is that correct?
Yes.
Meaning you started your security career like 45 years ago almost, right?
Yes.
That's a long time ago. I imagine the industry has changed a lot in that time, hasn't it?
Well, of course it has.
It's a lot more tech-oriented now, isn't it?
Yes, it is.
You oftentimes had trouble with this kind of technology, didn't you?
There was one specific instance, like I said, with the Artemis system that I specifically struggled with, but so did everybody else.
You often misplaced security key cards when on the job, didn't you?
I did get a minor infraction for misplacing a key card.
And this meant that anybody could have stumbled upon one and gained access to an area to which they had no security clearance. Isn't that right?
Objection, Your Honor. Speculation. The attorney is asking my witness to speculate to a hypothetical situation.
If I may, Your Honor, I'm asking his rationally based perception based on a hypothetical I'm presenting. As he was a security professional for 41 years, I believe he could answer that.
Judgment's overruled.
Thank you, Your Honor. And that means that anybody could have picked up these key cards, even a security threat, and entered an area to which they didn't have clearance. Isn't that right?
Well, I suppose that could have happened, but everybody misplaces stuff. You could ask my wife. I drop stuff all the time.
And if that had happened, that would have been a major disciplinary action on your record, wouldn't it have?
Yes, but that didn't happen. It was just a minor infraction.
Right, that didn't happen. You also were known to stay logged into client security systems. Isn't that true?
Not all the time. I just got one minor write-up for that.
And if that had happened and somebody had stumbled upon that system, they could have gained access to that system. Isn't that true?
Yes, but again, that's just a little bit of forgetfulness. That's not anything to do with technology itself.
And that could have been a major disciplinary action on your record, had that happened, right?
Had that happened, yes.
And these things didn't happen.
No.
But they...
Oh,
sorry, that was another question.
I apologize.
No, you're fine, you're perfectly fine. And these things didn't happen, but they show up as minor disciplinary actions on your record for happening, right?
Yes, they do.
Mr. McLean, how long did you work at Thunderbolt?
I worked at Thunderbolt for 40 years.
And you experienced a plateau in your technology knowledge, isn't that correct?
I did admit that I hit a technological plateau in the early 2000s, but I wouldn't say that me hitting a plateau means that I'm completely incapable of using technology. I'm still pretty good at it, I like to think.
And you have one major disciplinary action on your record at Thunderbolt, isn't that correct?
Yes, the last change agreement with the Artemis system.
You deleted crucial footage from a client system, right?
Yes, it was a common error, but the footage ended up getting recovered.
Thunderbolt expected you to know how to operate this system, didn't they?
Yes, they did.
And Thunderbolt had to pay out of their own pockets to recover this footage, didn't they?
Yes, they did.
Didn't the client ask that you never work for them again as a security guard?
That's true, but that was okay with me.
And wouldn't the company have been justified in letting you go for this mistake?
Well, I can't tell you whether Amos Floyd wanted me fired. That ain't any of my business.
Didn't you say that your last chance agreement stated that this action was a fireable offense?
Yes, the last chance agreement said that, but I don't know whether Amos Floyd, the boss when this happened, wanted that.
Isn't it fair to say that your actions were hurtful to Thunderbolt's reputation?
Yes, they could have been if the client had sued, but that never happened.
When were you laid off, Mr. McLean?
I was laid off back in 2021.
And that's when you started taking classes, right?
Yes, it is. I wanted to get better at technology so I could be ready to get back into the workforce.
And then you went and reapplied for a job at Thunderbolt, right?
Yes.
And you assumed that your limited education and your antiquated experience would guarantee you this position, right?
Well, I like to think that my 40 years in this exact job and my community college training would help me in this interview.
You didn't get this job, did you?
No, I did not.
Ashley Owen got this job, correct?
Yes.
And she has a full degree in security with an emphasis in cybersecurity, no?
Yes, she does.
Wouldn't it be reasonable for one to state that Ashley Owen was significantly more qualified when it came to tech than you?
Well, I don't know whether she was more qualified or not. That's not my decision to make.
And after you applied for this position, were you granted an interview?
I was granted an interview for this position.
You were asked if you were able to adapt to tech, right?
Yes, and I like to think that I am.
And you were aware that the last chance agreement was reviewed in this process, right?
Yes.
Looking at that last chance agreement, wouldn't it be fair for Thunderbolt to have seen you as a liability risk to the company?
Again, I don't know what Thunderbolt was thinking, but I was just hoping that my 40 years of experience was going to be noted in this interview, but Riley Gallatin did not say one word about it.
If Thunderbolt had viewed your disciplinary record and seen you as a risk and they hadn't hired you for that reason, that wouldn't be discriminatory, would it?
I'm sorry, can you re-clarify the question?
If Thunderbolt had viewed your disciplinary record and used that as the basis for not hiring you, that would not have been discriminatory, would it?
Objection, Your Honor. Speculation. Once again, opposing counsel is asking my witness to testify to a hypothetical situation that he really has no knowledge of.
If I may, Your Honor, he's allowed to entertain a hypothetical, and I'm asking him about what the lawsuit that he has filed is about.
May I respond, Your Honor?
Yes.
Your Honor, he's simply asking my witness to testify what would have happened in the hiring decision, but Robin McLean was simply applying for the job. He doesn't have any background in HR and played no part in the hiring decision or the interviews.
I think you're asking him to call for a conclusion, and it may even borderline on a legal conclusion, so I'm going to sustain the objection.
Thank you, Your Honor.
Rephrase the question.
Strike, Your Honor.
Huh? Move to strike.
Thank you.
May I proceed, Your Honor?
You may.
Thank you. Now, Mr. McLean, when were you fired again?
I was fired back in 2021.
Did you take the firing personally?
Well, I didn't take it super personally. I thought it was a little odd that there were so many people over the age of 40 being laid off.
You said that a disproportionate number of people 40 and older were fired in this layoff, right?
That's just how it felt to me, yeah.
Your Honor, let the record reflect. I'm showing opposing counsel Exhibit 7.
What's on the flag?
May I approach the witness?
Okay.
And would you like a courtesy copy, Your Honor?
Please.
Thank you.
Thank you.
Can you identify this document for me, Your Honor?
This appears to be the firing statistics issued by Thunderbolt.
You're familiar with this document, are you not?
Yes, sir.
And this was given to you by Thunderbolt Security?
Yes.
And you have knowledge of the contents of this document?
Yes.
Your Honor, at this time we move to enter Plaintiff's Exhibit 7 into evidence.
Any objection?
No objection,
Sorry,
Your Honor.
Defense Exhibit 7.
Defense Exhibit 7 submitted in evidence.
May I continue, Your Honor?
You may.
If you look at the sheet at the top, does it not say that before the layoffs, there were 50 guards 39 and under and 100 guards 40 and older?
Yes.
Well, doesn't that mean that the older guards outnumber the younger guards 2 to 1?
Yes, it does.
Doesn't that also mean that by sheer number, the older guards were going to be fired at a higher rate?
Yes, but I believe that they were fired even more drastically than 2 to 1 in the layoff.
In the second portion of this, does it not say that after the layoffs, there were exactly 1/2 older guards and 1/2 younger guards?
Yes, but given the fact that there were more older guards before the layoff, there were more older guards fired than younger guards.
Do you believe that an American business owner in our free market system should be able to decide who he or she wants to fire and hire?
Well, I don't know. I've never been a business person.
Do you believe that, though?
Believe what? I'm sorry.
That an American business owner should be able to decide who gets hired and who doesn't?
Well, I suppose if it's their business.
And if that business owner just plain doesn't like a job candidate, they cannot hire them, and that's not discriminatory, is it?
Well, it depends on what they don't like them for. If they don't like them for their age, then I would say that would be a little bit discriminatory.
Well, what if Miss Elliott just plain didn't like you, Mr. McLean?
Well, first of all, I don't think that'd be very nice, but I guess that's not my decision to make.
It might not be very nice, but it's not discrimination, is it?
It wouldn't be age discrimination.
And Mr. McLean, to wrap up, you claim to be in this for justice and not money, right?
No, I'm not in this for money. I think it's a little bit upsetting that Thunderbolt's firing people and not hiring people just because they're a little bit older.
Mr. McLean, will you get your job back if you win this case?
Well, I believe that I would.
You'll get your job back at Thunderbolt if you win this case.
No, I apologize. I must have misheard you.
Will any of the other 40-plus employees be compensated for alleged ageism?
I don't believe so, but again, I'm not here to get people jobs back or to get people compensation. I just think it's a little bit wrong that we've been wrongly discriminated against because of our gray hair.
Will Thunderbolt be forced to change any of its policy?
No, but again, that's not why I'm here.
But you will be paid, won't you?
Yes, but again, I just think it's a little bit wrong.
And your legal fees will be covered, won't they?
That is correct.
And this could potentially damage, crucially, the reputation of Thunderbolt Security and the work of Lane Elliott.
Well, I suppose, but again, I'm not here to damage the reputation of the company that I worked for 40 years. Amos Floyd is one of my best friends. Why on earth would I want to hurt his granddaughter? I just think that it's a little bit wrong to discriminate against people just because they've been on the earth a little bit longer.
No further questions, Your Honor.
Any redirect?
No redirect, Your Honor. I just asked that I retrieve the documents and publish it to the bench.
You may retrieve them, but I have copies of those. Anything further of this witness?
Oh, nothing further, Your Honor.
Okay. You may step down.
Thank you, Your Honor.
May I approach?
I have that copy.
I'll just leave those.
Your Honor, may I publish Exhibit 7 to the jury?
You may.
Thank you.
Keep them off.
Leave them up here.
Even if your copy of this coming over to the jury.
Highness may call your next witness.
Your Honor, at this time, the plaintiff calls Sean Owsley to the stand.
Sean Owsley. You may proceed.
Please introduce yourself to the members of the jury.
My name is Sean Owsley.
Miss Owsley, what do you do for a living?
I'm currently employed as the head of human resources down at Huffaker Foods, but up until 2021, I was the assistant HR director at Thunderbolt Securities.
And how are you involved in today's case?
I was working for Thunderbolt when Lane took over. I didn't like what happened under her direction, and I wanted to come here and tell the jury exactly what I know and just how Lane treated her older employees.
Now, before we dive into what you witnessed, I'd like to discuss your employment with Thunderbolt Securities. When did you start working for them?
I started in 1995. I worked for the owner of the company at the time, Amos Floyd. You couldn't find a better person to work for. He always did right by his employees.
And how long did Lane work for Thunderbolt?
Lane started in January of 2021. Before that, they worked at Flare Security Products.
Now, as assistant HR director, did you help at all with the transition from Amos to Lane?
A little. Lane started shadowing Mr. Floyd in 2020. Due to COVID, I would set up virtual meetings between the two. I remember this first meeting, I got Mr. Floyd all set up, and Lane said, "Nice to see you in the 21st century. Think you can get your account managers to do the same?"
How did Floyd react to this?
Floyd said, "That'll be your job. You know all about this modern technology."
What did Lane say?
Lane said, "Well, they better adapt, or they'll be sent to the glue factory." And it didn't sound like a joke to me.
Now, when did Lane take over the company?
Mr. Floyd's last day was December 31st, 2020. Lane was the showrunner, and Mr. Floyd promised to not interfere. A couple of others left that day too, including the previous director of HR.
And were you promoted to fill this position?
You know, I thought I should have been. I had a recommendation letter from Mr. Floyd and from the previous director of HR. But on January 2nd, I was introduced to my new boss, Riley Gallatin, one of Lane's friends from college. They'd never even been an assistant HR director before.
Were you given any reasoning for this?
I was told that Lane needed someone who was going to help her make some tough decisions in the future. Someone who wasn't a part of the old guard.
Now, when you talked to Riley, they mentioned a right sizing. Can you tell us what this right sizing is?
Yes, that's another thing. Right sizing is basically corporate speak for layoff. Day 2 of taking over and Lane was already talking about firing a bunch of people. When I expressed my concerns to Lane and Riley, I was told that we couldn't afford to keep the dead weight around. I didn't like that terminology.
And did Thunderbolt end up laying off its employees?
Yes. In the end, about 100 guards were laid off, with most being over 40.
Your Honor, at this time I'll be referring to what has been previously entered as Defense Exhibit 7. May I approach and retrieve the document?
You may.
Thank you. And may I approach the witness?
You may. Thank you.
This is the right sizing statistics from Thunderbolt, correct?
Yes.
Now, of the staffing of security guards over the age of 40, how many were there before the layoffs?
Well, there was 100 over 40 and 50 under 40.
Now, how many employees under the age of 40 were let go?
25.
How many employees over the age of 40 were let go?
75. 75% of the total for that age group.
And were you a part of the decision-making process for this?
No. I guess they didn't need my years of expertise after all. I was asked now and again about a few specific people.
Who delivered the news to the employees?
Riley did. I couldn't even bring myself to be in the room.
Now, at any point did Thunderbolt begin to hire again?
Yes. We started hiring again in late 2021.
What was the process for this?
We would hire in groups of 10 every few months or so. Lane wanted to rebuild Thunderbolt as the premier tech-savvy security company.
Did you see this reflected at all in the new hires?
Yes. I could tell that a lot more younger people were being hired than the older ones. Thunderbolt was getting younger and younger.
Your Honor, at this time I'll be referring to what has been previously marked as Exhibit 8. Let the record reflect, I am showing a copy to opposing counsel.
Record will so reflect.
Thank you. Would the court like a courtesy copy?
Yes.
May I approach? And may I approach my witness?
Yes.
Miss Halsey, what is this document?
These are the rehiring decisions for Thunderbolt Security.
And is this a fair and accurate copy?
Yes, ma'am.
Your Honor, at this time we move this document to be entered into evidence as Plaintiff Exhibit 8.
Any objection?
Not at this time, Your Honor.
May
I
we
have
tend-
said submit it to the jury.
may we tend to the jury?
You may.
Now, what was the percentage of people over the age of 40 that were hired during the period of time on this document?
Only 15%.
Now, I'd like to talk about the job posting that brought us here today. How many candidates applied for this position?
Well, there was one position to fill and 2 applicants, Robin McLean and Ashley Owen.
And were you a part of this interview process?
No. Riley conducted all the interviews, but from my review, Robin had 40 years of experience and Ashley was fresh out of school and had a degree in cybersecurity. I know who I would have picked.
And do you know who received the position?
Ashley Owen.
Do you know why?
I overheard Riley say that they liked her better than the old timer. There it was again. Old timer. Lane responded with, "Yeah, if you can't handle technology, you don't have a place in security anymore."
Miss Halsey, what did you do after overhearing this conversation?
I started looking for a new job. It felt like we old-timers didn't have a place at Thunderbolt Security anymore.
Thank you, Your Honor. I have no further questions at this time.
Okay. Cross-examination?
Yes, Your Honor. May I proceed?
Yes, ma'am.
Ms. Owsley, you worked at Thunderbolt Security for 26 years when it belonged to Amos Floyd, correct?
I did.
And in that tenure, I imagine that you grew quite fond of Amos Floyd, did you not?
Yes, such a kind man.
is it fair to say that after 26 years of working under one man, that you had an automatic distaste for any change in company leadership?
I wouldn't say that at all. I mean, if somebody came along and had the same attitude that Mr. Floyd had towards change and his kind heart, I would accept him just as I accepted him.
Because you only worked at Thunderbolt Security for 2 years under Lane Elliott, correct?
Yes, I consider 2 years a pretty long amount of time.
Is it fair to say that, never mind what Lane Elliott were to do, you would have disliked her for the sole point that she wasn't her grandfather, Amos Floyd?
I would not have said that, no.
But once Amos Floyd stepped down, you were next in line to become the head of human resources, correct?
You know, I thought I was.
But you didn't become the head of human resources because Lane Elliott chose to hire 45-year-old Riley Gallatin, correct?
Yes, that is correct.
And just so we're clear, it is Lane's choice as the owner of Thunderbolt Security to decide who she hires, correct?
Yes, but I had many recommendations put in. That's the only reason I was expecting it.
Could you have some hostility towards Lane for the fact that she didn't choose you to become the head of HR?
I wouldn't call it hostility, and even if you were to call it that, I would never let that affect my testimony here today. I'm just here to tell the truth and what I believe.
Are you aware that Ashley Owen has a degree in security with an emphasis in cybersecurity?
Yes, I'm aware she has a degree in cybersecurity.
And are you aware that Lane Elliott sponsors a security studies program at Scarborough Community College?
Yes, I am aware of this.
Now, these courses teach its students in the exact systems that are being used by Thunderbolt Security, don't they?
Yes, they do.
So then, is it reasonable to say that these classes could also double as a certain respect of experience for its students?
I guess you could say that. So that means Robin McLean has even more experience than 40 years.
However, Robin McLean does not have a full degree, does he?
No, but he still took plenty of classes down at the community college.
And while working with Lane and Riley, did you ever hear of their vision for Thunderbolt Security?
Yes. They said they wanted Thunderbolt to be more tech-savvy, more technology-focused.
That's right. Lane and Riley wanted Thunderbolt to be the premier, tech-savvy, modern security company with employees who are willing, but preferably enthusiastic about adapting, correct?
Yes, I guess so.
And isn't it true that in Thunderbolt's history, more older than younger workers have more direct misuses when it comes to operating technology?
Yes, but you have to look at the numbers. People who are older have been working at the company for a longer time. That means more time to make little mistakes.
But is that a yes to my question?
Yes, it is.
Thank you. And moving forward, during COVID-19, was there a reduced need for boots on the ground frontline security guards?
Yes, there was. People couldn't really go anywhere.
And during COVID-19, isn't it true that the only division at Thunderbolt Security that saw growth was their cyber security division?
Yes, I believe so.
Nevertheless, Amos Floyd was allowing guards to remain as full-time employees despite them only working part-time hours due to a lack of necessity, correct?
I don't know. You'd have to ask Amos Floyd that question.
And isn't it true that during COVID-19, Amos Floyd was paying the guards out of his own personal wallet?
Yes, like I said, such a kind soul.
But Lane Elliott is under no legal obligation whatsoever to pay her employees out of the money from her own wallet, is she?
No, not at all, but it would be the right thing to do to not fire 100 guards. Move them to your cybersecurity division. Find other places for them to go.
But if Thunderbolt Security did not have the funds, the means to continue the practice that Amos Floyd did, isn't it reasonable that she would have enacted this right sizing in order to prevent her from being unable to simply pay her employees?
I don't know if I would consider it reasonable to fire 100 good working employees, but I can see how someone would understand where she's coming from.
Because isn't it better to lay these employees off as opposed to being unable to pay them entirely?
I know many people who would just be happy to be out on the field working, but I also know many people who would love to be paid. So, again, that's not up to me to decide.
And isn't it true that under Lane Elliott's leadership, Thunderbolt's margins have significantly improved?
Yes, after they decreased due to the COVID-19 pandemic, not because of Mr. Floyd.
Thank you, Your Honor. I have nothing further for this witness at this time.
Thank you. Any redirect?
No, Your Honor, I just asked that I approach and retrieve the documents and publish them on the bench.
You may do so. Thank you, ma'am. You may step down.
Thank you.
May I approach the bench?
Thank you. Plaintiff may call your next witness.
Yes, Your Honor. The plaintiff calls Corey Spencer to the stand.
Mr. Spencer, you're under oath. You may proceed.
Thank you, Your Honor. Please introduce yourself to the members of the jury.
My name is Corey Spencer.
What do you do for a living?
I'm an associate professor of law at Midland State University College of Law, which happens to be my alma mater. I don't think I need to tell you all how prestigious that is. I have been with them since 2019.
And do you have any other work experience in your field?
Yes. I worked for 2 years at Webb & Skaggs representing employees in various labor and employment law. After that, I worked at the EEOC where I'd investigate claims of workplace discrimination.
Mr. Spencer, if you don't mind explaining, what is the EEOC?
Oh, I'm sorry. I get a little carried away sometimes. The EEOC, or Equal Employment Opportunity Commission, enforces federal civil law regarding workplace discrimination.
Are you published in your field?
Yes. I have written and published articles in the area of employment law.
Do you do any work outside of Midland State University?
Yes. I offer my services to plaintiffs in discrimination cases, particularly age discrimination, as that is an academic interest of mine.
How did you become involved in this case?
I have been hired to evaluate and testify regarding indicia of discrimination and how they may be present in today's case.
Mr. Spencer, if you don't mind explaining for the jury, what are indicia of discrimination?
These are very important. It is very rare that you'll see an employer directly state that they will not hire a candidate because they are a part of a protected class. No. Almost all of these cases are proved by circumstantial evidence.
And when you say protected class, what do you mean by that?
A protected class is a group of people with a common characteristic that are protected by law from employment discrimination. In today's case, those 40 years of age or older are considered in the protected class.
Did you review any documents before your testimony here today?
Yes. I reviewed all of the affidavits for the witnesses testifying here today except for Max Casey. I then reviewed the job listings for the positions, hiring and firing statistics, and many more documents to help me understand today's case even better.
Did you have any methods for trying to determine if there were indications of age discrimination in today's case?
Yes. I have identified 4 primary areas of concern that are indicative of age discrimination. The first, words or phrases in the job posting itself that are age-coded. The second, questions and responses during the interview process that could show a dismissive or a discriminatory attitude towards older candidates. The third, general statements made by decision makers at Thunderbolt that could be indicative of animus. And the fourth are the dismissal and hiring practices of Thunderbolt Security.
Let's look at your first area, words and phrases in the job posting itself that could be age-coded. When you said age-coded language, what did you mean by that?
These are words or phrases that could have an effect on discouraging older candidates from applying for a position, or could show a possible preference for a younger candidate.
Your Honor, at this time, I will be referring to what has been previously entered in the evidence as Plaintiff Exhibit 1. May I retrieve the copy from the stand?
Sure.
Thank you. May I approach the witness? Now, were you able to find any specific age discrimination from this ad?
Yes, several.
What instances of age discrimination were there?
2 phrases that stand out to me immediately are the phrases tech-savvy and fresh blood in the first paragraph. These are known coded languages that could show age discrimination.
And were there any other instances of age-coded language on this document?
Yes. The phrase beginning a career in the last sentence could show that Thunderbolt is looking for a younger candidate.
And can age-coded language have an effect?
Absolutely. Research has shown that these age-coded languages could have just as much of an effect on an older candidate as direct age discrimination. Even the pictures in this ad could be deterrents.
Let's turn to your second area of concern, questions and responses in the interview process that could be indicative of a discriminatory attitude towards older candidates. Did anything jump out to you with regards to age discrimination?
There are some discrepancies on what happened during these interviews, but both McLean and Gallatin have agreed that Riley Gallatin used the term old guard.
You mentioned some discrepancies. What was this agreed upon?
McLean suggests he was asked about being able to keep up, another red flag.
And what effect could this have?
It could promote an ageist stereotype.
Let's turn to your third area of concern, general statements made by decision makers at Thunderbolt. What information did you look at?
I looked at statements made by Thunderbolt employees with decision-making power, Lane Elliott and Riley Gallatin, specifically with regards to older employees or candidates.
And what did you find?
I found that Sean Owsley had expressed concerns to Riley Gallatin about hiring candidates who had taken a few classes out of a community college, over candidates with years upon years of practical experience. Gallatin's response was that they needed employees who could advance to all advances, or could adapt to all advances in technology, not someone who could barely operate a flip phone.
Objection, Your Honor. That's hearsay.
Your Honor, may I respond? This statement was made by Lane Elliott, who is a direct representative of Thunderbolt Security, therefore falling under the Rule 801, Section D, Part 2, Subsection D.
I'd like to clarify, was it Gallatin or Elliott? Because I'm hearing two different answers.
Both members are agents of Thunderbolt Security.
If I may briefly, Your Honor, I don't believe that Gallatin was acting as an agent of the defendant, Thunderbolt Security, in this moment. She wasn't conducting an interview or doing any business on behalf of Thunderbolt.
May I respond? Your Honor, Riley Gallatin was employed at Thunderbolt Security at the time of this statement, therefore making them a direct representative of Thunderbolt Security.
Being employed doesn't make somebody an agent. If every comment Ms. Gallatin made was our party opponent, then she could say whatever she wanted in here.
Objection is noted. It's overruled. You may answer the
Thank you,
question.
Your Honor.
Thank you, Your Honor. Were you finished with your response?
I'm sorry, could you repeat the question?
What in other instances of age discrimination did you notice?
Yes. I was just saying that Sean Owsley had expressed concerns to Riley Gallatin about hiring candidates that had a few community college classes under the belt over candidates with years upon years of practical experience. Gallatin's response was that they needed employees who could adapt to all advances in technology, not someone who could barely operate a flip phone.
And what effect could all of these instances of possible indicia have?
It isn't the stray remark or the joke between friends. It is the consistent pattern of ageist remarks, specifically those close in time to an actionable decision, that could lead Thunderbolt as being indicative of animus towards older employees.
Let's turn to your fourth and final area of concern, the dismissal and hiring practices of Thunderbolt Security. What were you able to find?
First, I looked at the reduction in workforce in Thunderbolt in 2021, found in Exhibit 7.
Your Honor, may I retrieve a copy of Exhibit 7 and 8 from the stand?
You may.
Thank you. May I approach the witness?
You may.
Now, what were you able to find from Exhibit 7?
In Exhibit 7, you can see that there were 100 guards let go. Of these, 75% were a part of the protected class, disproportionate to the amount of staffed guards.
And what were you able to find from Exhibit 8?
In Exhibit 8, you can see that there were 100 guards hired back, but only 15% were a part of the protected class. Looking even further into these numbers, you can see that there were 10 hiring groups. Only 4 of them contained members of the protected class.
And what were you able to find from this?
Based on my review, the age-coded languages in this ad could deter members of the protected class from even applying for the position in the first place.
Mr. Spencer, based on your review, were you able to come to a conclusion in today's case?
Although I cannot provide a definitive claim, I believe there is sufficient evidence to support the claim of Thunderbolt Security being indicative of age discrimination towards Robin McLean.
Thank you, Your Honor. No further questions.
Cross-examination.
Yes, Your Honor. May I proceed?
Yes, sir.
Mr. Spencer, you're being paid for your testimony today?
That is correct. $500.
And you said you're going to rely on circumstantial evidence, correct?
Yes, I do.
That is evidence that is not hard facts, right?
Yes.
You said you relied on age-coded language when you came to your final conclusion, correct?
Yes, found in Exhibit 1 in the job posting.
Now that is a subjective term, is it not?
Could be considered.
So what one expert considers to be age-coded differs from another?
The The definition of age-coded language is a phrase or word that can have a double meaning, and that is what I looked at.
My question, Professor, is that what one expert considers to be age-coded could differ from another.
Given that they have two meanings, yes, they could.
And so, to clarify for the jury, you, someone who is being paid, are the expert that I flagged the age-coded language in today's case, correct?
Yes, I did find age-coded language in this ad.
So you were the expert?
I am, yes.
You also said you relied on comments made by Gallatin in the interview, correct?
Yes, he was the one giving the interviews.
You said you relied on Gallatin's comment of keep up, correct?
Yes, that was one of the things that I looked at.
Isn't it true that Gallatin denies ever saying that?
Gallatin denies, oh, yes, Gallatin denies asking Robin McLean about being able to keep up.
You nor anyone testifying for the plaintiff can prove that Gallatin ever said that, correct?
No, given their conflicting stories over this.
So you're relying on a fact that no one can prove to be true when coming to your final conclusion?
Technically, yes.
You said you relied on statistics as well, correct?
Yes.
Do you have a copy? Go ahead.
In Exhibit 7 and 8, and yes, I have a copy of them.
Okay, thank you. Let's refer to Exhibit 8. If I read Exhibit 8 correctly, during the examined period, there were 30 applicants over the age of 40, correct?
That is correct.
Of them, 15 were hired?
Yes.
By my count, that's 50-50, right?
Yes, but what's not 50-50 is the amount of candidates over and under 40 that applied for the position.
Those are pretty good odds, though, aren't they?
You could say.
Applicants under the age of 40 were also hired at a rate of 50%, weren't they?
Yes, but there were 170 applicants under the age of 40.
But it would be fair to say that despite having fewer applicants in the protected class, Thunderbolt still worked to hire those applicants at the same rate as they did the non-protected applicants, correct?
Yes.
You also relied on Exhibit 7, correct?
Yes, the reduction in workforce statistics.
Now, if I read Exhibit 7 correctly, before the layoffs, 75 or 67% of the employees at Thunderbolt Security were over the age of 40, correct?
Yes, 100 guards out of 150 guards.
And of the laid off employees, 75% of them were over the age of 40, correct?
Yes, that is correct.
That's a discrepancy of 8%, right?
I believe so.
That's not incredibly significant, is it?
Not largely, but it's still there.
Well, that's especially less significant when you consider the differing disciplinary backgrounds of the terminated employees, correct?
I'm sorry, can you rephrase?
Well, if I read Exhibit 7 correctly, all of the employees over the age of 40 had at least 5 instances of minor discipline, correct?
5 minor or 1 major disciplinary action.
Well, and all the candidates under the age of 40 had at least 1 instance of major discipline, correct?
That is correct.
Wouldn't the question of which disciplinary record is better be a question for the employer?
Yes.
Very well. Now, you're familiar with the Commonwealth of Kentucky's civil rights legislation that is applicable in today's case, correct?
Yes, the Federal Civil Rights Law of 1964.
Correct. And under that legislation, employees or applicants with 5 numerous minor infractions are not a protected class, are they?
That is correct.
So it would not be discriminatory to base a hiring or a firing on that factor, would it?
No.
Likewise, under that legislation, employees or applicants without a college degree are not a protected class, are they?
That is correct.
So it would not be discriminatory to base a hiring or a firing on that factor, would it?
That is true.
Of the 2 applicants in the question in today's case, one of them had a disciplinary record and one did not, correct?
That is true, because one had worked for the company and one had not.
And one of them had a college degree and one of them did not, correct?
Correct, but one of them took college classes.
And so it would not be discriminatory to base a hiring or a firing on either of those factors, correct?
True.
No further questions, Your Honor. We pass the witness back.
Thank you. Any redirect?
No, Your Honor, I just asked that I be able to tender the documents to the bench.
Please.
And then my witness, will have to step down.
Thank you, sir. You may step down. Are there any additional witnesses for the plaintiff, or is that the plaintiff's case in chief?
With that, the plaintiff rests its case in chief.
Okay, that concludes the case in chief for the plaintiff. The court will stand in recess for about 5 minutes. All right, thank you. You may be seated. Okay, we're now back in session. Plaintiff has rested their case in chief. Is the defense ready to proceed?
Yes, Your Honor, the defense is ready to present its case in chief.
Okay, you may call your first witness.
This time, Your Honor, we call to the stand the defendant, Ms. Lane.
Aaliyah, if you'll take the stand, you're under oath.
Thank you, Your Honor.
May I proceed, Your Honor?
Yes, sir.
If you're ready. Ms. Elliott, could you please state your full name to the jury?
My name is Lane Elliott, and please don't stand on formality, Will. You can just call me Lane.
All right, Lane. How old are you?
Well, let's just say I'm well over 40. It's a good thing age isn't a problem for me, otherwise I wouldn't even have a job.
I suppose you can't fire yourself.
That is true.
Now, Lane, are you associated with Thunderbolt Security?
I am since January of 2021. I have been the current owner and president of Thunderbolt Security.
And as owner, are you involved in the hirings and firings at Thunderbolt?
Well, yes, I'm very involved in every aspect of the business. I even brought a friend and former coworker, Riley Gallatin, in to help with human resources. You know HR.
Now, how did you come to own Thunderbolt?
Well, I guess you could say security is in my blood. You see, my grandfather Amos Floyd started the company in the 70s, and he had ran it up until January of 2021 when he passed over ownership and control to me.
And how did the employees at Thunderbolt react to you taking over?
Well, some had been with the company for decades, very loyal to my grandfather, and after all, he instilled those traits in his employees. They didn't like technology nor change. I guess you could say none of them could even let the door hit them in their ear on the way out. They couldn't have resigned.
Objection, Your Honor. Speculation. The witness is testifying into the mindset of the employees who had been previously laid off, saying they didn't like technology or change, and she has no way of knowing that.
Your Honor, if I may respond, I think this witness, based on her rationally based perception, has experience with these employees and can testify to their general mood.
Your Honor, first of all, Ms. Elliott did not necessarily know what these employees were thinking once they were laid off. She's clearly stating that they didn't like technology and were resistant to change, and she has no way of being able to testify to that.
Objection sustained.
Move to strike.
Sustained. Disregard.
Len, what did you do for work before taking over at Thunderbolt?
I sold security technology for Flare Security products.
And what products did Flare sell?
Well, anything and everything security related, from the low-tech stuff to the newest cutting-edge technology. It was a techie's dream.
Lane, do you consider yourself a techie?
Absolutely. Security technology is the future of security.
What makes you say that?
Well, our world is technology-driven. You can order food, pick up groceries, go to an ATM, and never deal with a human. And thieves can steal your identity from over 10,000 miles away. And GPS satellites can track your every move. My point is, COVID taught us that face-to-face interactions aren't necessary anymore. Boots on the ground can't address modern-day security problems.
How did COVID impact Thunderbolt?
The company was going under during COVID. My grandfather had practiced a business model that couldn't have survived the pandemic.
How did you know that the company was going under?
We didn't have enough business for all of our employees. Most brick-and-mortar businesses were closed and didn't require a guard on the premises.
And so how did your grandfather handle that situation?
He was very old school, very loyal. Rather than laying anyone off, he paid his employees out of his own pocket. Otherwise, the business wouldn't have been able to cover payroll.
And what did that mean for the business?
Well, he was paying people not to work. Very commendable, but not a business model that I could have upheld.
And so what changes did you make?
I restructured the business. We moved away from the traditional security guard work and shifted to a more profitable market, dealing with cybersecurity. Our cybersecurity division is what saved the company during COVID.
What did a restructuring mean for your employees?
Unfortunately, I had to make some really tough decisions and lay some people off, but I gave them good references and I even paid a severance.
How many employees did you have to let go?
In the end, it was 100.
And how did the restructuring turn out?
Fantastic. It increased our revenue, which in turn allowed us to start hiring again.
Did you hire back these same employees?
No, we did not.
Why not?
Well, the business had changed. My priorities were very different than my grandfather's, and those employees were now dead weight.
Whoa, why dead weight?
It's an accurate description. We had employees who were making no contribution to Thunderbolt and who were unwilling to change. They were dragging the business under.
Lane, why did you make the decision to not hire back Robin McLean?
Mr. McLean wasn't the best candidate for the job. He wasn't as well-rounded as the lady who interviewed for the same position. Her name is Ashley Owen, and she is who we did hire.
Did Ashley Owen have any security guard experience?
No, she did not.
Did that make Robin McLean a better candidate for the job?
No, Mr. McLean had worked in the security business for years, but that didn't make him qualified.
Objection, Your Honor. According to relevant case law, McDonnell Douglas Court v. Green, a witness is not allowed to state if a candidate was qualified for the job, as that is the jury's job to decide.
If I may, Your Honor, the McDonnell case that she's citing sets out the 4 prongs of a discrimination suit. I believe she's referring to the 3rd prong, qualification. So is this an ultimate issue objection?
No, I'm simply saying that according to this case law, opposing counsel and this witness is not allowed to testify that a witness or that a candidate was qualified for the job, as that is solely left up to the jury.
Just because a question embraces the nature of something that a jury must decide doesn't mean it's objectionable.
Your Honor, if I may. Ms. Elliott clearly stated that Robin was or was not qualified for the job, which is not, she doesn't have that ability.
One final response, Your Honor. I also believe that Ms. Elliott has made it abundantly clear that this is her opinion.
I'm going to overrule the objection. You may answer.
Thank you. Ms. Elliott, you were saying about Robin's qualifications.
I'm so sorry. Could you please repeat the question?
Of course. Did that make Robin a better candidate than Ms. Owen?
No, Robin McLean had worked in the security business for years, but in my opinion, that didn't make him qualified.
And why is that?
Robin McLean's skills are low-tech. Turning on a flashlight, shooting the breeze with a customer at a club, rattling a doorknob to see if it was locked or not. He didn't like modern equipment, and he didn't want to adapt to changing technology. And I couldn't see him teaching our customers about the latest and greatest in facial recognition scanners.
Okay, Lane, then what worker traits are important to you?
Being tech-savvy, computer literate, and open to learning new technology. It's exactly like I put in the job posting.
Your job posting, you're referring to Exhibit 1?
Yes, that's the job posting that Thunderbolt had used to rehire guards.
Your Honor, may I approach the bench to retrieve what has been entered as Plaintiff Exhibit 1?
Yes, sir.
And may I approach the witness?
Yes.
Could you please identify what I just handed you?
This is the job posting that I was just referring to.
And are you personally familiar with it?
Well, yes, it was made at my direction. Riley and I had told the ad agency what we were looking for. See right here, it says no experience required, but you have to be able to adapt to changing technology.
Lane, why did you ultimately make the decision to hire Ashley Owen?
In the end, it came down to qualifications, and in my opinion, Ashley Owen was qualified, and unfortunately, Robin McLean was not.
And how's that?
Robin McLean had spent years doing the kind of work that I was trying to leave in the past. He was careless, he wasn't attentive, and he didn't want to adapt to changing technology. And I myself wanted employees with no ingrained habits. After all, no experience is better than bad experience.
How was Miss Owen's age considered?
It wasn't. Age is irrelevant. Look at me. I'm 45, but I'm learning new technology all the time. And Riley is over 40. And if you look at our workforce, we've retained workers over the age of 40, but we've since hired workers over the age of 40.
Okay, so if it wasn't age, what made Ashley the better candidate in your eyes?
She was better educated in cybersecurity and technology. She embraced all aspects of security and didn't have a lifetime of bad habits.
Hang on, what do you mean by that last part?
Well, Robin McLean learned how to be a security guard in 1980. He spent 40 years doing things a certain way, and as I stated, I wanted employees with no ingrained habits. I adore my grandfather, but my grandfather and many of his contemporaries resisted technology, almost bankrupting the company.
How was Mr. McLean's work history factored?
Negatively. He'd done things the same way for decades and openly disliked technology. He and I were definitely not on the same page.
Were there any other issues with hiring McLean?
Yes, he admitted he didn't like technology and had plateaued in his knowledge over 20 years ago. Do you know how much technology has changed in 20 years alone? There wasn't even an iPhone 20 years ago, and Alexa was just a character on Dynasty.
Was there any other reason not to hire McLean?
Yes. Over the years, he turned down every job promotion that he was offered because he was unwilling to learn new things.
Lane, was there?
Objection, Your Honor. Speculation. The witness has no idea why Robin McLean turned down the job offers. Therefore, she is testifying into his mindset.
Again, I think as the former employer of McLean, Ms. Elliott is more than welcome to testify based on her present sense impression.
May I respond, Your Honor? Robin McLean was offered these job promotions under the ownership of Amos Floyd. Ms. Elliott did not work for the company at that time, did not offer Mr. McLean the promotions, and therefore cannot testify as to why he declined them.
If I may respond, she is more than familiar with Mr. McLean's work history, as she did review it when deciding whether or not to rehire McLean.
Because she did not offer him the position or talk to him about it, I'm going to sustain the objection, and I'll sustain the motion to strike.
Yes, Your Honor.
May proceed.
Thank you, Your Honor. Was there anything else problematic with McLean?
Yes, Mr. McLean had made a very costly mistake while transferring some surveillance footage from one of Thunderbolt's customers. The customer was sued and the footage exonerated them.
What happened?
After a very costly extraction in which Thunderbolt paid for, the footage was thankfully recovered.
Ms. Elliott, Lane, how many reasons do you have for not hiring McLean?
Well, let's see. Bad experience, not amenable to change, technologically challenged, outdated skills, and committing a terminable offense. That's 5.
And how many of those are dependent on age?
None. There are 25 people under the age of 40 be let go at the same time as Mr. McLean. There are 15 people over the age of 40 we've since hired. You see, I don't have control over who applies for a job at my company. I had an open mind about Robin McLean and gave him an opportunity to show us that he had grown to fit my vision. Unfortunately, he was the same Robin from 40 years ago. He wasn't ready to change, and he wasn't my choice.
Thank you very much, Lane. Your Honor, at this time we have no further questions. We pass the witness.
Okay, cross-examination of this witness.
Yes, Your Honor. May I proceed?
Yes, ma'am.
Your first step when you took over was to right-size the company, correct?
Yes, because as you know, my grandfather, Amos Floyd, the previous owner of Thunderbolt, was paying his employees out of his own pocket, and I simply could not afford to sustain that practice.
So basically fire people.
Yes, because as I said, I could not sustain that practice that my grandfather was upholding.
Now you fired 100 guards, is that correct?
Yes, because as I stated, I couldn't uphold that practice that my grandfather was upholding.
75 of these people were over the age of 40.
Yes, but if you look at our workforce before the right sizing, you would see that 100 of our guards were over the age of 40, so it was inevitable to avoid this situation.
Ms. Elliott, I'm not asking you about the basis of the situation. I'm simply asking that 75 of these people were over the age of 40. Is that correct?
Yes, as I said, yes, they were. But if you look at the workforce before then, you would see that 100 of our guards were over the age of 40, and only 50 were under the age of 40. So it's inevitable to avoid this situation.
But that's a yes to my question.
Yes, that was a yes.
Now, after the pandemic, you began hiring back. Is that correct?
Yes, I had begun to hire back after our margins had improved due to my restructuring that I had planned.
You wanted the old guard gone.
Yes, if you're implying that the old guard was just simply an old way of doing things.
Right, you wanted the dead weight gone.
Yes, and as I stated in my direct, it's an accurate description. Those employees were making no contribution to my company.
Now, one of the individuals, or dead weight, as you put it, is my client, Robin McLean. Is that correct?
Yes, because unfortunately he was making no contribution to the company.
Now, Rob McLean worked for Thunderbolt for 40 years.
Yes, under my grandfather.
In those 40 years, he had one disciplinary action.
Yes, that is true, with the Artemis system, which could have cost Thunderbolt a huge lawsuit.
Right, this Artemis system is notoriously hard to use. Is that correct?
Yes, and if Mr. McLean wasn't confident in using that system, especially whenever it came to a situation as important as the situation that he was in, he should have spoke up and asked for assistance on that, showing that he wasn't ready to adapt and learn that technology.
Directing you back to my question, Miss Elliott, I'm not asking about Robin's abilities. I'm simply asking that this was a notoriously hard system to use. Is that correct?
Yes, as those who weren't trained and were able to speak up.
Now, this system is being phased out and isn't even installed any longer, is it?
Yes, that's correct.
Now, you claim you made your hiring and firing decisions based off of one major or 5 minor disciplinary actions. Is that correct?
Yes, because in my opinion, 5 minor disciplinary actions equal 1 major disciplinary action.
Right, but no one under the age of 40 even had 5 minor disciplinary actions. Is that correct?
Yes, that's correct.
Now, you would agree with me that someone who's been at the company longer has a greater life likelihood of making a mistake?
Not necessarily, I wouldn't say that. If he was predominant in using the systems as he stated, then he wouldn't have made that mistake.
Miss Elliott, I'm not asking about Robin McLean. I'm simply asking that someone who's been at the company longer has a greater likelihood of making a mistake.
Yes, and I'm using Robin McLean as an example. If an employee wasn't confident in using a system that they had made a mistake on, they should have spoke up and took initiative to learn that system.
But nonetheless, that's a yes to my question.
That is a yes if they weren't able to adapt to the systems being used.
Now, when Thunderbolt started hiring back, you posted a job opening. Is that correct?
Yes.
Now, in the job opening, you wanted tech savvy.
Yes, because tech savvy, I wanted people who were able to understand and use the technology and adjust to the systems that our customers were using.
That's right, you wanted fresh blood.
Yes, I had. I understand that that was a not so nice term to use now looking back on it, which is why I've changed the job posting.
You wanted someone who was just now beginning a career.
Yes, as anyone of any age can begin a career at any age.
Now, you're familiar with your hiring and firing statistics, is that correct?
Yes, that's correct.
And from 2021 to 2022, 85% of the people that you let go, 85% of the people that you hired back were under the age of 40, is that correct?
Yes, that is correct. But also, there wasn't as many applicants over the age of 40 that were applying.
So just to be clear for the jury, only 15% of the people that you hired were over the age of 40.
Objection, Your Honor. Could my witness be provided with the exhibit in question?
Yes, Your Honor. May I approach the bench and retrieve Exhibit 8?
Thank you.
May I approach the witness?
Thank you.
Now at the bottom of this exhibit, Miss Elliott, you see that only 15% of the people hired back into the company were over the age of 40, and you're familiar with these statistics.
Yes, I am familiar with these statistics, but they were hired at the same rate as the people under the age of 40 were. They were both hired at a rate of 50-50.
Miss Elliott, I'm not asking about the rate in which they were hired back. I'm simply asking to clarify that only 15% of the people hired back were over the age of 40.
Yes, and I'm saying yes to that question, and they were hired at the same rate as the people under the age of 40. They were just not applying at the same rate.
Directing you back to my question, that is a yes, correct?
Yes, that is a yes.
Now, Robin McLean and Ashley Owen both applied for an entry-level position.
Yes, they had, yes.
Which is for security, not cyber security.
Yes, but as you know, the security industry has changed significantly than compared to what it was 40 years ago, as when Robin McLean had first applied.
Right, but Robin McLean had been taking technology classes while they were off to get better at it.
He had, but as you know, Ashley Owen had a full degree in security.
But you still chose to hire Ashley Owen?
Yes, because she had a full degree, while Robin had only took a handful of classes.
But Robin had 40 years of experience.
He had 40 years of experience under the previous owner, which is a predominantly different company than it is under me.
Thank you, Your Honor. No further questions.
Would you like to redirect this witness?
Yes, briefly, Your Honor.
You may.
May I proceed, Your Honor?
Yes, sir.
Did you value Mr. McLean's experience as much because it was under a different owner?
I hadn't valued as much, yes, because it was under a different owner, because the company had changed significantly under my reign.
And when looking at applicants, was your preference for an applicant with a full degree or a few classes?
Definitely a full degree, because it shows that they were more understanding of the systems that we had used.
Thank you very much, Your Honor. Nothing further.
Thank you. Recross.
No, Your Honor.
May this witness be finally excused?
Yes, Your Honor. May I approach the bench to tender any exhibits?
Please. Thank you, ma'am. You may step down.
Thank you, Your Honor.
Thank you.
Thank you.
You may call your next witness.
Yes, Your Honor. At this time, the defense calls Professor Max Casey to the stand.
Professor Casey, if you'll come up, please. Remind you that you're under oath.
Yes, Your Honor.
Am I free to proceed, Your Honor?
You're free to proceed. Thank you.
Now, Mr. Casey, will you please state your full name for the record?
Yes, my name is Max Casey.
Are you currently employed, Mr. Casey?
Yes, I'm the chair of the Security Studies program at Scarborough Community College.
What does that entail?
Well, I'm directly involved with the design of the curricula. I oversee professors when it's necessary, and I also help organize funds and projects with Thunderbolt Security.
How long have you worked at this program?
Well, I've served as chair since 2021, and the 7 years previous before that, I was just an instructor after my previous job.
How is your program funded, Mr. Casey?
Well, it's mostly sponsored by Thunderbolt Security.
Anybody else?
Yes, Blair Security as well.
Now, Mr. Casey, does your tie to Lane Elliott and Thunderbolt Security predispose any of your testimony in court today to bias?
Absolutely not. As an expert and a professional witness, a professional and an expert witness, my ties and connections to Lane and Thunderbolt do not trump my integrity nor my honesty.
Are you college educated, Mr. Casey?
Yes, I have a Bachelor of Science in Criminal Justice from the University of Massachusetts Lowell.
Did you obtain an advanced degree?
Yes, I also have a Master of Arts in Security Studies from the same institution as my bachelor's degree.
Do you have any certifications?
Yes, I am a certified protection professional with the American Society for Industrial Security International.
Where did you take your talents after school?
Well, I started working for a security firm called Glacier Patel in Midland City.
And what was the extent of your job with Glacier Patel?
Well, we provide a variety of security consulting services to a multitude of institutions.
Your Honor, please let the record reflect. I'm showing opposing counsel Exhibit 13.
So noted.
May I approach the witness, Your Honor?
Yes, sir.
Would you like a copy, Your Honor?
Please.
Mr. Casey, will you identify this document for me?
Of course, this is a copy of my curriculum vitae.
This is a fair and accurate copy of your curriculum vitae?
It is.
Your Honor, at this time, we move as the defense to enter Exhibit 13 into the record.
Any objection?
No, Your Honor.
Exhibit 13 is admitted.
Thank you, Your Honor. Now, Mr. Casey, did you have the plaintiff as a student?
Yes, Robin was a student of mine.
Are you familiar with the plaintiff's academic record?
I am.
Your Honor, at this time, let the record reflect I'm showing opposing counsel Exhibit 9.
So noted.
May I approach the witness, Your Honor?
Yes, sir.
And would you like a courtesy copy, Your Honor?
Yes, please.
May I approach? Mr. Casey, will you identify this document for me?
Yes, this is a copy of Robin's transcripts.
What does this document tell you about Robin McLean as a student?
Well, that Robin was an overall okay student in the classroom.
What kinds of classes was Robin taking?
Well, Robin was only a part-time student taking a handful of classes, and I believe that they were mostly cybersecurity related.
Did Robin obtain a degree?
Objection, Your Honor. I asked that before they testify to this evidence, they enter it into evidence.
That's fine, Your Honor. I'll do it.
Okay.
Your Honor, at this time, we offer Exhibit 9 into evidence.
Exhibit 9 is admitted if there's no objection.
Yes, Your Honor.
Thank you, Your Honor. May I proceed?
Yes, sir.
What kinds of courses was Mr. McLean taking?
Well, I believe Mr. McLean was looking to touch up on his technology skills, so most of these were cybersecurity and technology based.
Did you see much improvement with Mr. McLean in his abilities with tech?
Well, I saw marginal improvement, and I do commend Robin for trying to apply himself and taking these classes, but I just really do not see that Robin has the mindset nor the capability to be a proper modern security guard.
Did Robin obtain a degree or certification through this coursework?
Well, no. Robin was only a part-time student.
Mr. Casey, are you familiar with Ashley Owen?
Yes, Miss Owen was also a student of mine.
Are you familiar with her academic record?
I am.
How was Ashley as a student?
Well, Ashley was a B-average student while on our cybersecurity track, and she was definitely more interested and savvy in the cybersecurity field, but she also exhibited proficiency in the physical security field.
How did her and McLean's GPAs compare?
Well, Ashley had a higher GPA than Robin, and she was also taking a lot more classes than Robin.
What was Ashley's area of focus?
Well, like I said, she was on our cybersecurity track, one of the two tracks that we offer at Scarborough Community College.
Did Ashley Owen complete a degree or certification at your program?
Yes, she obtained a full associate's degree in security with an emphasis in cybersecurity.
Mr. Casey, through your collaboration with Thunderbolt and Lane Elliott, are you aware of what Thunderbolt is looking for in its employees?
Well, yes, I feel I have a fair sense of what Thunderbolt looks for its employees through some of the programs and subject areas that they emphasize in our curriculum.
And what is your rationally based perception of what Thunderbolt is looking for in its employees?
Well, Thunderbolt's looking for those who have a good familiarity or a certain degree of education in the security field as a whole, those who can operate and adapt to these new and innovative security systems, and also those who can perform the modern duties of a physical security officer.
In your experience with security, are these qualities that even an entry-level security guard would need?
Well, absolutely. It is critical to the security field for a security guard to be distinguished in both the physical and cybersecurity fields.
Does Lane Elliott prioritize students from your curriculum?
Well, I believe that they have a preference, but at the community college, we pride ourselves on preparing our students for the job market as a whole, and not just Thunderbolt or Scarborough.
Mr. Casey, in your expert experience, is Rob McClain an ideal candidate for a modern-day security job?
Well, in my opinion, Robin was not an ideal candidate. Robin had a spotty track record at Thunderbolt, and while supposedly seeing that Robin showed a little initiative to improve himself, the classes that Robin took, to me, seemed more like a hobby than a genuine attempt to better himself as a candidate.
Objection, Your Honor. Speculation. The witness is testifying that my client was taking these classes as a hobby. I don't believe the witness has the laid foundation that they would know this, and therefore they are testifying to the mindset of Robin McClain.
If I may, Your Honor, this is the witness's rationally based perception. He had Rob McClain as a student, and furthermore, as an expert witness, he is allowed to testify to his opinion.
May I respond? Your Honor, while Max Casey was the teacher of Robin McClain, they only took a few classes together, and I do not believe he would have the knowledge to testify to the mindset of Robin McClain that this was a hobby instead of taking this to better himself. I simply feel he does not have the knowledge for this.
Again, Your Honor, as an expert witness, he is allowed to testify to his opinion.
The objection is noted. It's overruled.
Thank you, Your Honor. And what about Ashley Owen? Was Ashley Owen an ideal candidate for a modern-day security job?
Well, Ashley was certainly an ideal candidate. She was ambitious and inspired. She completed her degree, she earned a degree, an associate's degree, and displayed her proficiency in both the physical and cybersecurity fields.
Thank you. I have no further questions, Your Honor, and I pass this witness.
Thank you, sir. Cross-examination.
Yes, Your Honor.
You may proceed.
You believe Ashley Owen was the proper hire in today's case, correct?
I do believe that.
And this was for a security officer position?
Yes.
Just for clarification, not cybersecurity?
Well, no. While it is labeled just a frontline security guard, technology is making its way ever so more into the security field as a whole.
But you would agree with me that a security officer is more of your boots on the ground type of physical guard?
Well, that could be true in some instances, but like I said, technology is evolving, changing, and not going away anytime soon, so it is ever more present in the whole security field.
I'm not asking about the presence of technology in this job. I'm simply asking that a security officer is a more boots-on-the-ground type of guard.
Objection, Your Honor, asked and answered. I believe my witness answered this question.
May I respond? Mm-hmm. Your Honor, I believe that the witness is testifying to more than my question. I'm simply trying to clarify to the jury to show my points and answer the questions clearly.
If I may, Your Honor, I believe my witness is allowed to elaborate on his answer.
I'm going to overrule the objection. You may proceed.
Thank you, Your Honor.
So that's a yes, a security officer is more of your boots-on-the-ground type of guard.
In some instances, but there are also instances where cybersecurity is prevalent in those positions.
So that is a yes to my question?
In some instances.
I need a yes or no response.
You could say yes.
Now, Ashley Owen had a degree in cybersecurity, correct?
It was a full associate's degree in security, yes, with an emphasis in cybersecurity.
Yes, and they had never been a security guard before.
No, as she had not had an opportunity. She was a college student.
Yes, and Robin McClain had 40 years of experience as a security guard at Thunderbolt, correct?
Oh yes, blatantly put, he does.
Now, you used Robin McClain's disciplinary record to justify why you believe Ashley was the better candidate, correct?
I believe that there's more things than just Robin's instances of discipline at Thunderbolt to why I think Robin wasn't qualified.
But you did use this instance in your investigation.
Yes, I do believe so.
And one of that was a last chance agreement Robin McClain had.
Yes.
Now, Robin only had one major incident in his entire 40-year career.
Well, yes, but this instance was pretty significant to Thunderbolt.
Yes, but only one, correct?
I believe only one major, yes.
Now, Ashley Owen had 0 incidents of discipline, correct?
Well, yes.
Can you remind me how many years of experience she had?
Well, yes, along with 0 disciplinary records, she also had not had the opportunity to have a full-time job.
Yes, so exactly. In your own words, this isn't exactly the fairest comparison.
Well, yes, you might be able to say that.
So that's a yes.
Sure,
I need yes or no to my question.
you could say yes.
Now, something that could classify as a fair comparison is the mutual classes Ashley and Robin took together.
Yes, there was some crossover.
Yes, one of them was actually a modern technology class that you taught.
Yes, that is true.
And in fact, in this class, Robin actually scored higher than Ashley did.
Yes, I do believe so, but when you look at it within context, Robin was only taking a handful of classes, and Ashley was taking nearly 4 times the amount of credits as he was, so there's obviously a different workload associated with that.
But it is also known that older individuals who are taking college classes with a large gap from previously going to school have a harder time reintroducing themselves to class.
Objection, Your Honor, calls for speculation. This is beyond my witness's knowledge.
May I respond? Your Honor, I believe that this is very much in the witness's knowledge. They teach at a community college, they're a professor. So they would have the knowledge what older students struggle with. Furthermore, this is a cross-examination, and if the witness does not know, they can testify to that.
Furthermore, Your Honor, it is stipulated that the testimony, or the written testimony and affidavit of the witness as an expert is sufficient for his testimony, and he is not to go out of the bounds of this. This is outside of the witness's expertise and knowledge.
May I respond? Your Honor, while I do not think that the witness needs to testify from his affidavit, I do believe that this is listed in his affidavit, and as a teacher and professor at a community college, he would have knowledge of the gaps these students need to take.
There's no this overruled.
Thank you, Your Honor.
So older students do have a struggle when coming back to school.
Well, yes, when you do take a large gap, there might be some expected struggle when you haven't been in school for a while.
Now, it is known in your field that age doesn't matter.
Excuse me?
It is known in your field that age doesn't matter.
Yes, you could say that.
If a person is willing to learn, they can be successful at any age in cybersecurity.
I feel, yes, that is a fair statement.
Now, you would agree with me that Robin taking these classes helps to show a willingness to learn.
Well, yes, but I think there's more instances of Robin's inadequate mindset that outweigh any supposed initiative from Robin.
But that's a yes, it can show a willingness.
Maybe in some instances.
Now, Ashley Owen graduated from your institution, correct?
Yes.
And you would like to continue to promote this institution?
Well, yes, it's my livelihood and it's my job and I take pride in it.
Now, speaking of Scarborough Community College, Lane Elliott and Thunderbolt Security are huge financial supporters of your security studies program.
Well, yes, Lane encouraged Amos Floyd to fund the program, and that is when it became an independent program of the college.
Yes, it is with their help and continued support that it was made its own department. You were also appointed chair because of them.
Yes, I was appointed chair when it became an independent branch.
They're also paying you for your testimony here today.
No, that is not true.
Yes, that's right. You're actually accepting the payment they already gave you for your security studies program as payment for your testimony here today.
Well, it's not a direct financial benefit. I am grateful that Thunderbolt supports our program, but that does not predispose my testimony to any bias or dishonesty.
I'm not asking about their support or if you think that this would lead to your bias. I'm simply asking that you're accepting the payment they already gave you for your testimony here today.
Well, yes, my gratefulness in some instance serves as some sort of metaphorical payment, you could say.
And you worry that Flare Security Products or Lane might pull back or withdraw support completely, depending on the outcome of today's case.
Objection, Your Honor, calls for speculation.
May I respond? Your Honor, Max Casey works and is the chair of this department. Furthermore, he has shown and testified in his direct and cross that they are providing funding to him. He would have knowledge of this, and he is able to testify on this, I believe.
If I may, Your Honor, he's not the director of funds to this program, and he has no knowledge of if any company is going to withdraw any funds from his program.
May I respond? Your Honor, as director of this program, he would have some dealings with the funding, and as he is in contact with these people, I believe he would know or have the knowledge of whether or not the funding would be pulled because of this, as it is directly related to the case.
If he knows whether or not the funding will be pulled, but if he has no personal knowledge, then I'm going to sustain the objection. But if I'll allow him to answer if he knows, otherwise I'm going to sustain the objection.
Thank you, Your Honor.
So you were worried Flare or Lane might pull back or withdraw support depending on the outcome of today's case?
Well, of course, I think anybody can be reasonably disgruntled if their livelihood and their job came to a significant disturbance as something that this case could result in.
So that's a yes to my question. You were worried?
I believe so.
Thank you, Your Honor. I have no further questions at this time.
Any redirect of this witness?
No, Your Honor, thank you.
May this witness be finally excused.
Yes.
If you'll come retrieve the documents.
Thank you. May I also publish exhibits 13 and 9 to the jury?
Absolutely.
Thank you.
Thank you. May I call your next witness?
Yes, Your Honor. The defense calls Riley Gallatin to the stand. May I proceed, Your Honor?
I'll remind you you're under oath.
Thank you.
You may proceed.
Thank you, Your Honor. Good afternoon, ma'am. Can you please state your first and last name for the jury?
Good afternoon. My name is Riley Gallatin.
Now, if you don't mind my asking, Ms. Gallatin, how old are you?
I am 45 years young.
And what do you do for work?
Currently, I am the head of human resources, or as it's more commonly known, HR, at Thunderbolt Security.
And where were you employed prior to becoming the head of HR at Thunderbolt?
I had worked at Flair Security Products in Midland City as a human resources manager.
So what encouraged you to make the change in jobs?
Well, Lane Elliott did. She reached out to me before she took over Thunderbolt because she was looking for someone to not only become the new head of HR, she caught when Sean Allison was stepping down, but she was also looking for someone she knew she could trust. You see, Lane knew how beloved her grandfather was. Mr. Floyd had run the company for quite some time, and therefore she expected some upset about the change in leadership. I was hesitant at first, but agreed to take over when Lane asked.
Was Lane Elliott the one who hired you for the position that you currently have at Thunderbolt?
Yes, she was.
And what did you know about this position before agreeing to take it?
I knew that over at least the last 50 years, Amos Floyd had built the business up and was very involved with the day-to-day running of it. That is until 2021 when he unfortunately had to step down. Mr. Floyd also seemed to prize loyalty in his workers and valued that even more so than if they actually performed a good job or not.
How many guards were at Thunderbolt Security whenever you began there?
Thunderbolt landed on the smaller side with around 250 employees, out of which 150 were your old school frontline security guards who were paid for full-time work but were actually working less than full-time hours.
Ms. Gallatin, can you clarify what you mean by old school frontline security guards?
Oh, you know, your classic guard patrolling the mall late at night with a flashlight in hand. Okay, seriously, when Mr. Floyd had started the company, it was oriented around traditional guard work, such as those guards you would see manning a post or those you would see letting people in and out of a facility.
Ms. Gallatin, can you also clarify, what do you mean that Thunderbolt Security had full-time guards who were being compensated as such, but were actually only working part-time hours?
Well, after COVID hit in 2020, a lot of Thunderbolt's business dried up. There were no more concerts, sporting events, or places where large groups of people congregate at needing security. The only places then that had a need for security were healthcare venues.
So then, did Thunderbolt do a layoff whenever COVID began?
No, Mr. Floyd kept right on paying his employees full wages, regardless of the fact that there was not enough work to keep them around.
And can you explain how Mr. Floyd was able to do this?
Yes, Mr. Floyd had paid his employees with his own personal dime.
And when Amos Floyd stepped down, did Thunderbolt have the means to continue this practice?
Unfortunately, no. Thunderbolt didn't even really have the resources to do this practice in the first place. It was simply Mr. Floyd. While his way was morally commendable, it was a sure way to bankruptcy.
Ms. Gallatin, in your opinion, did you walk into a precarious financial situation whenever you began at Thunderbolt?
Absolutely. Had it not been for Lane and I learning our workforce with the actual work we had, Thunderbolt would have collapsed. Our margins are way better now than before.
Is there a business term used in HR for aligning the workforce with the available work?
Yes, we call it a right sizing.
And can you elaborate as to what a right sizing is?
Of course. It's when you look at the amount of work you have and the amount of staff you have that divides at levels appropriate for the amount of work that it generates.
Were you involved in the right sizing?
Very much so. I reviewed all of our employees to determine who should be laid off.
And what was some of the criteria that you reviewed?
We reviewed all the credentials of our guards, particularly technological mishandling or misuse of technology would cut heavily against the employee. We reviewed their disciplinary history and reports from account managers.
Because what was Lane Elliott's assessment of value in an employee?
Lane had a vision. She wanted a more tech-savvy employee who could adapt to ever-growing technology,
to modernize Thunderbolt in order to encourage growth.
Ms. Gallatin, what do you mean by tech savvy?
A lot has changed in the security industry when it comes to technology. Standing in a guard shack or patrolling a post doesn't really take any special skills. And quite frankly, it's very hard to remain competitive in an unskilled trade. Therefore, we needed employees who were familiar with cutting-edge technology. That is the future of society and of the security industry.
Had Thunderbolt began to embrace technology whenever you started there?
Hardly. Like I said, Mr. Floyd was old school, and he had a lot of senior account managers who were too. They kept an iron fist in the company pocketbook when it came to technology, and were overall very slow to change.
And how important do you feel technology is to the security industry?
To me, it is very important. As we move more and more into a digital age, I believe we're going to see an immense growth in cybersecurity.
In the end of the right sizing, about how many guards were let go?
Unfortunately, we had to let go about 100 of our guards, which was 2/3 of our workforce, if that speaks to how overstaffed we were.
Ultimately, what were your feelings about the right sizing?
After COVID, the security industry had been revolutionized and was now geared more towards technology. As such, we needed appropriate staff who could man such. Therefore, I'm able to recognize the necessity in the right sizing for saving Thunderbolt overall.
And when it was time to hire new guards, how did you advertise?
We posted some things on Indeed, Facebook, and the local Scarborough Community College had some postings up as well.
Who was responsible for the creation of those job advertisements?
Lane and I had an advertisement company develop the ad itself.
And you had a few of these job listings posted around Scarborough Community College, correct?
Yes.
Why is that?
Thunderbolt offered classes and programs at that college in the exact systems that we used. Therefore, we deemed it highly probable that many of the college graduates would want to go into working for Thunderbolt.
Did the fact that a candidate had or had not taken classes at Scarborough influence the decision-making process?
Yes, it did.
And how so?
Well, the students would have had an education in the systems that we used, therefore they were desirable. We already knew that they had the training and the qualifications necessary for the job.
And speaking of the decision-making process or the hiring process, what was your role in that?
I would conduct the interviews for the new candidates and discuss with Lane afterwards.
Ms. Gallatin, do you remember conducting Robin McLean's interview?
Yes. I have some memories, but it's not entirely perfect. You have to understand that while at Thunderbolt, I have conducted over 100 interviews.
And do you remember any comments that you may have made to Robin McLean during his interview?
Yes, I remember making a few comments after a rather busy week. I made these comments because Mr. McLean had displayed some resistance to technology in the past by deleting crucial security footage. Not to mention, Mr. McLean hadn't been employed in the company in quite some time, and Thunderbolt was changing rapidly.
And after factoring in Robin McLean's interview, as well as all of the criteria that you look at during your evaluation, what opinion did you come to formulate about Robin McLean?
Well, after reviewing Mr. McLean's disciplinary history with deleting security footage, angering clients, etc., and after reviewing his transcript at interview, I came to find personally that the other applicant, Ashley Owen, had a better grasp when it came to technology, and overall the more diverse skill set between the two candidates. Owen also made a great point during her interview about physical and cybersecurity merging in the future. Therefore, I deemed that what Ms. Owen lacked in experience compared to Mr. McLean, she more than made up for with technological prowess.
So based on your perception of both the candidates, Ashley Owen and Robin McLean, who was the better candidate in your opinion?
In my opinion, the answer was very easy. Ashley Owen.
Thank you, Your Honor. I have nothing further for this witness at this time.
Thank you. Class examination.
Yes, Your Honor. May I proceed?
Yes, ma'am.
Mrs. Gallatin, you were a medium-level HR person at Flair Security?
Yes, while at Flair, I had still been in college and didn't really move up in the ranks that much while there, though I did have a few minor promotions and raises.
Your friend, Lane Elliott, offered you the director of HR position when she inherited the company from her grandfather?
Yes, she did. She wanted someone she knew she could trust in the company, and I happened to be that person.
Up to that point, you had never even been an assistant HR director, had you?
I had not, but I still had experience in the human resources department.
The first thing that you and Lane Elliott did when you took over the company was fire 100 guards, correct?
I wouldn't agree that we fired them, considering that's a very harsh term. I would never have chose to lay off those employees had we not had a reason to, but unfortunately, yes, we had to let go about 100 of our guards.
Mrs. Gallatin, is it not true that 100 people were told to go home, that they no longer had a job?
That is not what we told them directly. We laid them off, and unfortunately, we could not keep them employed because of our financial situation at the time.
Mrs. Elliott referred to this right-sizing as getting rid of dead wood, correct?
Yes, she used the term dead weight as a way to categorize the people who were offering no contribution to the company and simply draining our bank account.
Of the dead wood you got rid of, 75% were over the age of 40, correct?
Yes, when you look at that statistic alone, 75 is correct. However, when you look at the total population of our company at the time, there was an overwhelming amount of older guards compared to younger guards.
But that's a yes, 75% were 40 or older.
Yes, they were.
Now, you claim you made your firing decisions based on if employees had 1 major disciplinary action or 5 minor, correct?
Yes, that was the way we used to determine if the guards were a liability or not to our company.
But you would agree with me, somebody who's been with the company for longer would have a greater likelihood of making a mistake.
In theory, yes, but regardless, those mistakes were still made.
But that's a yes to my question.
Yes, theoretically, yes.
So that's not exactly the fairest comparison, is it?
To us, it was a fair comparison. We just simply looked at the disciplinary records. We did not factor in our age. If we had factored in age, then I would say that it was not fair. Yet, we only factored in the specific disciplinary actions made.
But isn't it true that no one under the age of 40 had 5 or more minor disciplinary actions?
Your Honor, I would have to ask that this attorney simply give my witness the exhibit that she was questioning her on, because the use of statistics, questioning my witness on statistics without having those in front of her, I would just ask that it is placed in front of her.
May I respond? Your Honor, this witness is familiar with this document, and this document has already been entered into evidence. However, if you would prefer, I can retrieve the document and give it to her.
Your Honor, that is simply all I'm asking, is just for that document to be handed in front of her.
Okay, the exhibit is up here if you want to come.
May I approach?
Yes, ma'am.
Thank you, Your Honor.
May I witness?
Thank you.
So is it not true, based on this document, that no one under the age of 40 had 5 or more minor disciplinary actions?
From what I can tell on this sheet, yes.
And when you and Lane Elliott began rehiring at Thunderbolt Security, you placed a premium on tech-savvy individuals of the 21st century.
Yes, considering our company was based around tech, obviously we did have a preference for that.
And you made this clear in your job posting, correct?
Yes, we did.
And one of the people that you interviewed for this position was Robin McLean.
Yes, of course.
You don't have a perfect memory of this interview, do you?
I have a good memory, but I still would not say perfect.
You had forgotten that Robin McLean actually had 40 years of experience when you conducted this interview, hadn't you?
I hadn't forgotten it, but I hadn't reviewed his prior history completely before I conducted the interview.
And you also remember Ashley Owen's interview, correct?
Yes, of course.
And you remember that Ashley Owen's interview was ultimately unremarkable.
Yes, at first her interview was unremarkable, but I believe that the phrase she said at the end certainly saved her.
But that's a yes to my question. Her interview was unremarkable.
At the beginning, yes, it was.
And you claim that Ashley Owen had made a remark to you that changed your opinion about her interview, correct?
Yes, as I said before, it definitely changed my opinion about her.
Ashley Owen was beginning a career.
Yes, considering Miss Owen hadn't had any chance to have job experience, she was beginning a career.
And when you began hiring for Thunderbolt Security, you wanted someone to begin a career.
In our job posting, I am fairly certain that that is what it said. I didn't honestly care that Ashley Owen had no experience, though I did prefer that she had no ingrained habits.
But that's a yes, you did want somebody who was beginning a career.
A career specifically in the security field, yes.
And you said that Ashley Owen was the clear choice, correct?
Yes, that is why we hired her.
Even though she had 0 years of experience.
Objection, Your Honor, asked and answered.
Your Honor, I'm simply clarifying for the jury that Ashley Owen did in fact have 0 years of experience.
It's cross-examination. That's all.
Thank you, Your Honor. So Ashley Owen did have 0 years of experience, correct?
From what I could gather based on her record, yes, she did not have any experience, though she did not have the chance to.
And Robin McLean had 40 years of experience, correct?
Yes, he did. However, I would argue that his experience was under a different company, a company that did not value technology like ours did.
Mrs. Gallatin, I'm not asking you about what company Robin McLean worked for. I'm simply asking you, did Robin McLean have 40 years of experience?
As I answered, yes, he did. However, he had it under a different boss.
No further questions, Your Honor.
Thank you. Any redirect of this witness?
Yes, Your Honor, briefly.
Okay.
Ms. Gallatin, I just have one final question for you.
Of course.
During your hiring process, you looked at a myriad of things, correct?
Yes, I did. I made sure.
Objection, Your Honor, leading.
Your Honor, would you like, I can rephrase if you would like.
Rephrase. Thank you.
Ms. Gallatin, what are some of the things that you looked at during your evaluation?
I reviewed all of the disciplinary history, the transcripts, interviews, and overall the education of our guards.
Did you ever use age as a factor?
Absolutely not. Ashley Owen could have been 40 and I still would have hired her.
Thank you, Your Honor. I have nothing further for this witness.
Any recross?
No, Your Honor.
Thank you. May this witness be finally excused? If you'll retrieve the document.
Yes, Your Honor.
Thank you. Does the defense have any additional witnesses, or is that the case for the defense?
No further witnesses, Your Honor. At this time, the defense rests its case in chief.
Okay, that concludes the case in chief for the defense. Let's take about 5 minutes. Thank you, everyone may be seated. Okay, both sides have rested, and at this time I will read the jury instructions. Instruction number 1. Immediately upon retiring to the jury room, you will elect a foreperson. 9 or more jurors may reach a verdict. Your verdict will consist of the answers you make to the questions contained in these instructions. If all 12 of you agree on an answer to a question, then only the foreperson needs sign the answer. If less than 12, but 9 or more agree, then all of those who agree must sign the answer. Instruction number 2. Do you believe by a preponderance of the evidence that the plaintiff, Robin McLean, was qualified for the position of entry-level security officer? You will select yes or no. If the verdict is unanimous, the foreperson would sign his or her name. If the verdict is not unanimous, then the 9 or more who agree will write their name. If you answered yes, proceed to instruction number 3. If you answered no, then you have found for the defendant and you may stop. Instruction number 3. The defendant, Thunderbolt Security, Inc., has offered a non-discriminatory reason or reasons for not hiring the plaintiff, Robin McLean. Do you believe by a preponderance of the evidence, 1, that the reasons offered by the defendant for not hiring the plaintiff are pretextual for age discrimination, and 2, that the plaintiff's age was a contributing and essential factor in its decision to not hire the plaintiff? You may answer yes or no. If the verdict is unanimous, the foreperson may sign his or her name. If the verdict is not unanimous, then the 9 or more who agree will write their answers. If you answered yes, you have found for the plaintiff. If you have answered no, then you have found for the defendant. At this time, we will submit the matter to the jury to begin their deliberation. Oh, no, we won't, because we're going to hear closing argument. So, is the plaintiff ready to proceed with closing arguments?
Yes, Your Honor.
You may proceed.
Your Honor, opposing counsel, members of the jury, their actions speak to a pattern. Thunderbolt Security, time and time again, used age as a basis for getting rid of and hiring employees. You learned today that one of the people affected by Thunderbolt's discriminatory actions is my client, Robin McLean. You learned Robin was not only fired from the position, but also overlooked for a job opportunity. Not because he wasn't a qualified candidate, not because he couldn't do the job, not because someone more qualified applied, but simply because he is 63 years old. Their actions speak to a pattern. Their actions with the firing of 100 employees were discriminatory. 75% of the employees fired were in the protected class. Now, Thunderbolt wants you to believe it was solely based on disciplinary actions, but someone who's been at the company longer has a greater likelihood of making a mistake. That's not hard to understand. Rob McLean worked for Thunderbolt for 40 years with one mistake, and all of a sudden he's a liability risk and must be fired? It was discriminatory. Their actions speak to a pattern. Their actions with the job postings for the new position were discriminatory. You heard today about all the age-coded language used in the ad. They didn't want this 63-year-old with 40 years of experience. They wanted the tech-savvy, fresh blood, the young individual who is just beginning a career. Even the pictures on the ad depict younger individuals. Corey Spencer, an expert in ageism, told you just how effective age-coded language can be. It was discriminatory. Their actions speak to a pattern. Their actions with the hiring of the new employees were discriminatory. Robin McLean never stood a chance, or anyone else in the protected class for that matter. Thunderbolt hired 85% younger than 40. Their ads were so good at keeping older individuals away that someone over the age of 40 only applied to 4 out of the 10 previous job postings. Thunderbolt achieved their desired results. They got rid of the old-timers. Their actions speak to a pattern. Members of the jury, as my co-counsel, Caroline Harper, told you at the beginning of this trial, this case has shifting burdens. We have proven by a preponderance of the evidence, meaning more likely than not, that Rob McLean was qualified for the job. Someone with 40 years of experience is certainly qualified for an entry-level position. Next, the defense attempted to show you a non-discriminatory reason for the hire. Thunderbolt claimed that Robin was not tech-savvy enough to be a modern security officer, and that one mistake in 40 years is enough to never hire him back into a company. But members of the jury, they have failed to meet that burden. Robin McLean was an exemplary employee for 40 years. He was just too old for Thunderbolt's liking. Now, let's say you, as the jury, believe that the defense has put forth a logical reason for not hiring my client. Then we must prove by a preponderance of the evidence that this reason is pretext for discrimination. Thunderbolt didn't hire Sean Ousley. Thunderbolt fired 75% of its older employees. Thunderbolt advertised and used age-coded language targeting younger employees. Thunderbolt hired 85% younger than 40, and Thunderbolt didn't hire someone with 40 years of experience for an entry-level position. All of that is age discrimination, no matter what excuse the defense wants to throw out. Their actions speak to a pattern, and we are asking you, the jury, to find them liable for these actions. Thank you.
Does the defense wish to make a closing argument?
Yes, Your Honor.
You may do so at this time.
May it please the court, opposing counsel, ladies and gentlemen of the jury. My name is Aaliyah Renee Bradshaw, and along with my co-counsel, John William Blake and Henry Pierce Spraggins, together we have represented the defendant, Thunderbolt Security, and more directly, Lane Elliott, in today's case. On behalf of Thunderbolt Security, Lane Elliott, my co-counsel, and myself, we would like to thank you for your time and careful consideration of all the facts and evidence in today's case. We understand that there are plenty. Lane understands that jury duty is a big commitment and it distracts from her usual time. She is thankful for your participation and is grateful that you have listened so carefully. Now, this is the part where I stand before you and I start recalling all of the reasons that we know Thunderbolt Security did not discriminate against Robin McClain. However, I stand before you without any fanfare with just a simple declaration. Lane Elliott did not discriminate against Robin McClain on the basis of his age. Lane Elliott is the owner of Thunderbolt Security, meaning that she has full autonomy over who she ultimately hires. When Ashley Owen and Robin McClain applied for this job position, they were responding to a job posting that explicitly stated experience is not needed. The 41 years of experience that Robin McClain had accumulated was under Amos Floyd, Thunderbolt's previous owner, who operated the company entirely differently. While the defense recognizes that Ashley Owen does not possess the boots-on-the-ground field experience valued by Amos Floyd, what she does possess is technological prowess heavily valued by Thunderbolt's current owner, Lane Elliott, because no experience is better than bad experience. Lane and Riley have told you that there are methods of reconstruction to Thunderbolt were critical. Before the right sizing, Thunderbolt, for lack of better words, carried dead weight. Amos Floyd was allowing guards to remain as full-time employees, but they were only working those part-time hours due to a lack of necessity. In other words, Thunderbolt's supply outweighed that of their demand. The right sizing enacted by Lane and Riley prohibited the company from having to file bankruptcy, being unable to pay employee wages. Applause must be given to Lane as the owner and Riley as Lane's pick for the transformation that they have done to Thunderbolt. Now that we have established that the right sizing was indispensable for company survival, allow me to re-raise what a right sizing is, as told to you by Director of Human Resources, Riley Gallatin. A right sizing is whenever you align the workforce with the available work. The plaintiff's expert, Corey Spencer, has told you that Thunderbolt had a surplus of workers, and as such, workers had to be laid off. I raise you, would it not have been more alarming if more younger than older workers were let go, seeing as there were significantly fewer of them, 2 to 1? Lane and Riley had a vision for Thunderbolt Security. They wanted Thunderbolt Security to be a premier, tech-savvy, modern security company with employees who were willing, but preferably enthusiastic about adapting to change. The defense's expert, Max Casey, has testified as a professor to both of the applicants that Ashley Owen aligns better with this vision than Robin McClain. Robin McClain was a part-time student, showing only marginal improvement. And to be frank, Robin McClain's skill set isn't particularly skilled. I assert that anyone in this courtroom here today can pick up a flashlight, click it on, walk down a dark hallway at night and call that security. The skill set possessed by Ashley Owens is specialized, and it is exactly what Lane Elliott is looking for in her new Thunderbolt, because no experience is better than bad experience. On behalf of my co-counsel, myself, Thunderbolt Security, and Lane Elliott, we humbly ask you to find Thunderbolt Security not liable for age discrimination. Thank you.
Does the plaintiff wish to make a rebuttal argument?
Yes, Your Honor. May I ask how much time I have remaining?
48 seconds.
Now, Ms. Bradshaw has just shared with you that no experience is better than bad experience. But members of the jury, I want to ask you a question. Would you rather have a mechanic with 40 years of experience and who made one mistake in an already unfixable car, or someone fresh out of trade school with no experience working on your car? The answer is clear to me. Now, I want to point out some statements made by Miss Lane Elliott today. She herself said they wanted the old guard gone. They wanted the older employees who had been at the company longer with more experience gone. If that isn't age discrimination, then I don't know what is. Members of the jury, it has become clear these actions are speaking to a pattern, and I ask you to find them liable for these actions. Thank you.
Thank you. I'm going to now ask that closing arguments have been completed, that the judges please complete your ballots as quickly as possible. Under instruction number 1, based on the following questions proposed to the jury, do you believe by a preponderance of the evidence that the plaintiff, Robin McLean, was qualified for the position of entry-level security officer, and that the reasons offered by the defendant, Thunderbolt Security, Inc., for not hiring the plaintiff are pretextual for age discrimination, and that the plaintiff's age was a contributing and essential factor in its decision to not hire the plaintiff? We, the jury, have come to a majority verdict. Answer: the jury finds in favor of the defendant